Hello dear students, today we will discuss merger under the company law. The main objectives of this lecture are to study the concept of merger under the Companies Act, to evaluate and analyze the legal provisions governing mergers and amalgamations, to study the different forms of merger. Dear students, the term merger is not defined under the Companies Act. A merger is the joining of two or more entities into one, with the goal being the organization of the combined entity into a single enterprise rather than just the collection of the assets and liabilities of the individual entities. Mergers may be done for a variety of reasons, including economies of scale, the purchase of technologies, access to a wide range of markets and industries. Typically, in a merger, the merging entities would merge into a single surviving entity and cease to exist. The effect is to wipe out the merging companies and to fuse them all into the new one created. The new company comes into existence having all the property, rights, and powers and subject to all the duties and obligations of both the constituent companies. Explaining the object of an amalgamation and the scheme of the statutory provisions, the Madras High Court observed in W.A. Birdsell and Company Limited Re. The word amalgamation has not been defined in the Act. The ordinary dictionary meaning of the expression is combination. Judging from the context and from the marginal note of section 394, which appears in chapter 5th relating to arbitration, compromises, arrangements, and reconstructions, the primary object of amalgamation of one company with another is to facilitate reconstruction of the amalgamating companies, and this is a matter which is entirely left to the body of shareholders and essentially an affair relating to the internal administration of the transferor company. The decision of the body of the shareholders ought not to be lightly interfered with, unquote. The Companies Act 2013 lays down explicit provisions governing the mergers and acquisitions of companies and body corporate, including that with foreign companies. Section 230 to 234 of Companies Act deal with schemes of arrangement or compromise between a company and its shareholders and its creditors. The merger provisions are in fact worded so widely that they provide for and regulate all kinds of corporate restructuring that a company can possibly undertake, such as mergers, amalgamations, demergers, spin-off, hive-off, and every other compromise, settlement, agreement, or arrangement between a company and its members or its creditors. There should be power in the company's memorandum to amalgamate in Hari Krishna Lohia versus Hulangore Tea Company Limited. It was held that if the power is not specified in the memorandum, then it should be acquired by altering the memorandum. It is not necessary that the company adopting a scheme should be in financial difficulties or that it should not be an affluent company. The expression any company liable to be wound up under this act does not mean a company which is insolvent, but any company registered under the act. Every such company being subject to the winding up provisions of the act. This was held in Khandelwal Udyog Limited Re. Now, dear students, we will discuss forms of amalgamation. An amalgamation may take place either by way of sale of shares or by sale of undertaking or by sale and dissolution or by a scheme of arrangement. Sale of shares is the simplest process of amalgamation or takeover. Shares are sold and registered in the name of the purchasing company. The selling shareholders receive either compensation or shares in the acquiring company. Sale of undertaking involves a sale of the whole of the undertakings of the transferor company as a going concern. Section 232 applies to every scheme which involves transfer of the whole or any part of the undertaking or liability of a company to another company. Types of mergers. First, we have horizontal mergers, also referred to as horizontal integration. This kind of merger takes place between entities engaged in competing businesses which are at the same stage of the industrial process. A horizontal merger takes a company a step closer towards monopoly by eliminating a competitor and establishing a stronger presence in the market. The other benefits of this form of merger are the advantages of economies of scale and economies of scope. These forms of merger are heavily scrutinized by Competition Commission of India. Then we have vertical mergers. Vertical mergers refers to the combination of two entities at different stages of the industrial or production process. For example, the merger of a company engaged in construction businesses with a company engaged in production of brick or steel would lead to vertical integration. Companies stand to gain on account of lower transaction costs and synchronization of demand and supply. Moreover, vertical integration helps a company move towards greater independence and self-sufficiency. Then we have congeneric mergers. A congeneric merger is a type of merger where two companies are in the same or related industries or markets, but do not offer the same products. In a congeneric merger, the companies may share similar distribution channels, providing synergies for the merger. The acquiring company and the target company may have overlapping technology or production systems, making for easy integration of the two entities. This type of merger is often resorted to by entities who intend to increase their market shares or expand their product lines. Then we have conglomerate mergers. A conglomerate merger is a merger between two entities in unrelated industries. The principal reason for a conglomerate merger is utilization of financial resources, enlargement of debt capacity, and increase in the value of outstanding shares by increased leverage and earnings per share, and by lowering the average cost of capital. A merger with an unrelated business also helps the company to foray into diverse businesses without having to incur large startup costs normally associated with a new business. Then we have cash merger. In a cash merger, also known as cash out merger, the shareholders of one entity receives cash instead of shares in the merged entity. This is effectively an exit for the cashed out shareholders. Then we have triangular merger. A triangular merger is often resorted to for regulatory and tax reasons. As the name suggests, it is a tripartite arrangement in which the target merges with a subsidiary of the acquirer, based on which is the survivor after such merger. A triangular merger may be forward, that is when the target merges into the subsidiary and the subsidiary survives, or reverse, that is when the subsidiary merges into the target and the target survives. Now, dear students, we will move on to making compromise and arrangements with creditors and members. The process by which the firm can reach a compromise or arrangement between creditors and members is outlined in section 230. The process must apply equally to any merger and acquisition arrangements the company makes. According to section 230, on the application of creditors, members, or the company, the tribunal shall order a meeting of the creditors and members in the event of a merger between the firm and its creditors or members. The following disclosures must be made to the tribunal by affidavit if the corporation applies to the tribunal for the conduct of the meeting. All material facts relating to the company, reduction of share capital, if any, the scheme of corporate debt restructuring that is consented to by not less than 75% of the creditors in value, the notice of the meeting shall be sent to all the creditors, members and debenture holders of the company. The notice shall be accompanied by statement containing the details of the compromise or arrangement, a copy of the valuation report, etc. The notice must be published in the press as well as on the company's website. The documents must also be provided to SEBI, where the company's securities are listed, for publication on their website. Further, the notice shall also be sent to the following authorities to invite their representations within 30 days of receipt of the notice, failing which it shall be presumed that there are no representations to be made by these regulators. The central government, RBI, income tax authorities, registrar official, liquidator, Competition Commission of India, any other sectoral regulator. The merger must be approved at the meeting by a majority of individuals, that is more than 50% in number, who represent 3/4 in value of the creditors and members and who are voting in person or by proxy. If the tribunal approves the merger, a sanction order will be issued and it will bind the company, its creditors, members, liquidator and contributors. A certificate from the company's auditors stating that the accounting treatment proposed in the merger scheme complies with the accounting standards outlined in section 133 must be filed with the tribunal before the merger can be approved. The order of the tribunal shall be filed with the registrar within 30 days of receipt of the order. The tribunal may dispense with calling of the meeting of the creditors if more than 90% of creditors in value agree to the scheme of merger by an affidavit. Now, dear students, we will discuss broad provisions governing mergers and amalgamation. Since a merger essentially involves an arrangement between companies, Section 232 of the Companies Act provides that those companies which intend to merge must make an application to the National Company Law Tribunal, having jurisdiction over such company for convening meetings of its respective shareholders or creditors, or seeking dispensation of such meetings basis the consent received in writing from the shareholders and creditors. The merging companies or companies proposed to be divided have also to circulate the following for the consideration of the meeting: a draft of the proposed terms of the scheme of merger or amalgamation, a confirmation that the draft has been filed with the registrar, report adopted by the directors of the merging companies, report of valuation by an expert, supplementary accounting statement. The tribunal may sanction the amalgamation by order after being satisfied that the procedure has been followed. The companies shall file a certified copy of the order with the registrar within 30 days of receipt of the same. Until the completion of the scheme, the companies shall file a statement indicating whether the scheme of merger or amalgamation has been carried out in accordance with the order of the tribunal. The statement shall be filed with registrar after being certified by a chartered accountant, cost accountant, or a company secretary in practice. If the majority in number, representing 3/4 in value of the creditors or shareholders present and voting at such meeting, if the meeting is held, agree to the merger, then the merger, if sanctioned by the tribunal, is binding on all creditors and shareholders of the company. The merger provisions constitute a comprehensive code in them, and under these provisions, the tribunal has full power to sanction any alterations in the corporate structure of a company. For example, in ordinary circumstances, a company must seek the approval of the tribunal for effecting a reduction of its share capital. However, if a reduction of share capital forms part of the corporate restructuring proposed by the company under the merger provisions, then the tribunal has the power to approve and sanction such reduction in share capital, and companies will not be required to follow a separate process for reduction of share capital as stipulated under the Companies Act 2013. Now we will discuss fast track merger. It is covered under section 233 of the Companies Act and requires approval from the shareholders, creditors, the registrar of companies, the official liquidator, and the regional director. Under the fast track merger, scheme of merger shall be entered into between the following companies: two or more small companies, or a holding company with its wholly owned subsidiary, or such other class of companies as may be prescribed. The scheme, after incorporating any suggestions made by the registrar of companies and the official liquidator, must be approved by shareholders holding at least 90% of the total number of shares and creditors representing 9/10 in value before it is presented to the regional director and the official liquidator for approval. Thereafter, if the regional director, official liquidator have any objections, they should convey the same to the central government. The central government, upon receipt of comments, can either direct tribunal to take up the scheme under section 232 or pass the final order confirming the scheme under the fast track process. The order of tribunal confirming the scheme shall be communicated to the registrar of the transferee company. Such registrar will issue a confirmation which shall then be forwarded to the registrar of the transferor company. After the merger, the transferee company is not directly or indirectly to hold shares in its own name or in the name of any trust, either on its behalf or on behalf of its subsidiary or associate company. Any such shares are to be extinguished or cancelled. The transferee company has to file an application with the registrar along with the scheme registered, indicating the revised authorized capital and pay the prescribed fees due on revised capital. The fees already paid on the transferor company's shares are to be set off. A company undergoing merger or amalgamation and coming under this section can make use of the provisions of section 232 for approval of its scheme. The central government can prescribe any method of merger or amalgamation. In Amco Batteries Limited Re, where a merger between a holding company and its subsidiary was in the interest of both companies and no prejudice was caused either to public interest or shareholders' interest, the proposal was not allowed to be questioned on the ground of oppression. Now we will discuss merger or amalgamation of a company with foreign company. Section 234 of the Companies Act permits mergers between Indian and foreign companies with prior approval of Reserve Bank of India. A foreign company means any company or body corporate incorporated outside India, whether having a place of business in India or not. The provisions of Chapter 15 with sections running from 230 to 240 are to apply mutatis mutandis to schemes of merger and amalgamation between companies registered under the Act and companies incorporated in jurisdiction of such countries as may be notified from time to time by the central government. The central government may make rules in consultation with RBI in connection with mergers and amalgamations provided under this section. The following conditions must be fulfilled for a cross-border merger. The foreign company should be incorporated in a permitted jurisdiction which meets certain conditions. The transferee company is to ensure that the valuation is done by a recognized professional body in its jurisdiction and is in accordance with internationally accepted principles of accounting and valuation. The procedure prescribed under Companies Act for undertaking mergers must be followed. The terms and conditions of such merger may provide for payment of consideration to shareholders of merging company in cash or in depository receipts as per the scheme to be drawn for the purpose. The RBI also issued the Foreign Exchange Management Cross-Border Merger Regulations 2018, which provide that any transaction undertaken in relation to a cross-border merger in accordance with Foreign Exchange Management Act regulations shall be deemed to have been approved by the RBI. Amalgamation of banking companies. Section 44A of the Banking Regulation Act 1949 is a complete self-contained code on amalgamation of banking companies. Under Section 44A, the power to grant approval to the scheme of merger of banking companies is the Reserve Bank of India instead of tribunal, and the RBI is also empowered to determine market value of shares of the objecting shareholder who voted against the scheme, as well as to direct payment of the value of the shares to the dissenting shareholder. This was held in Bank of Madura Shareholders Welfare Association versus RBI. Now we will discuss demerger. A scheme of subdivision of an enterprise into smaller units or splitting up the unit into more than one parts or separating one or more units from the main enterprise and constituting them into separate units is called demerger. Some of the shareholders would be allotted shares in the demerged unit in exchange of their holding in the original unit. Fair exchange ratio becomes necessary in such schemes also. Same consideration applies as in case of merger. The provisions of Section 230 are considered to be complete code permitting single window clearance of all the formal requirements of the Act. A single petition would serve the purpose of an amalgamation as well as that of a demerger. Reduction of capital and also reorganization of capital can be sanctioned as part of scheme. Now we will discuss amalgamation in public interest. Section 237 of the Companies Act deals with amalgamation in public interest. While the central government is satisfied that an amalgamation of two or more companies is essential in public interest, then the government may, by order notified in the official gazette, provide for the amalgamation of those companies into single company. The amalgamated company shall have such constitution, property, powers, rights, interests, authorities, and privileges, and shall be with such liabilities, duties, and obligations as may be specified in the government's order. The order may also contain consequential, incidental, and supplementary provisions. Before making any order, the central government is required to send a copy of the proposed order in draft to each of the companies concerned. This is necessary to enable such companies to file their objections and suggestions. The period for filing objections shall be fixed by the government, but should not be less than 2 months. The government may modify the draft order in the light of any suggestions so received. Copies of every such order have to be laid before both houses of parliament at the earliest convenience. In conclusion, we can say that the Act of 2013 is a comprehensive piece of legislation that assures both the protection of shareholders and the expansion of the business. It also presents the idea of out-of-court settlements or fast-track mergers, which were previously exceedingly time-consuming and difficult for businesses to complete. This action is intended to encourage small businesses to restructure themselves through merging. Accountability, procedural simplification, disclosure, and harmonization across numerous regulatory authorities are the 4 pillars on which the Companies Act is built. The one simple procedure of submitting documents to the court registrar has evolved into a multi-party process involving numerous documents. With this, we end today's lecture. Hope you enjoyed it. Thank you.